Hi, everybody. Douglas V. Gibbs here, Mr. Constitution. And recently, Texas had their heartbeat bill, and a lot of people have been asking me to talk about it. And when it comes to the Constitution, I apologize we haven't had a video for a while. I had an event last night that I've been planning on for the last week or two, and really put a lot of information and a lot of a lot of energy into. But now it's time to get back to our. Well, I just didn't prepare properly, did I? There we go. Okay. Yeah, camera's in the wrong place, the whole bit. Here, I feel better now. Anyway, let's talk about the Texas bill. Let's first start with Georgia's heartbeat law from a year ago, July 13th of 2020. A federal judge blocked Georgia's heartbeat law, saying that it was unconstitutional. It was a violation of the 14th Amendment. Roe v. Wade in 1973, according to the political class, the legal class, and everybody else, made the determination that abortion is a constitutional right. It is the constitutional right of a woman to terminate a pregnancy of a unviable fetus. That's their language, not mine. In the womb. So the question is here, then. Could they do that? Was that legal? Is abortion a right? What are the state's rules when it comes to this, and so on and so forth? Now, I spent a number of years secretary of a pro-life pregnancy center. So from a moral standpoint, I believe that human life, personhood, begins at conception. That's my personal opinion. But what does the law say? What does the Constitution say? And how do we respond to these lawsuits, these bills, these laws that pop up? Well, let's go all the way back now to Roe v. Wade. When it comes to Roe v. Wade, in 1973, Justice Harry Blackmun indicated in his opinion that the day that personhood is determined, that would make Roe v. Wade null and void. What he meant by that was going back to the 14th Amendment. The 14th Amendment has a number of clauses in it, but the one, privileges and immunities, we all should have equal privileges and immunities, equal protection under the law, and ultimately that no state can deprive a person of life, liberty, or property without due process, a concept that also applies to the federal government. And then we have to also look at authorities regarding the federal government and whether or not authorities are granted, because the Constitution operates on something called the enumeration doctrine, meaning that in order for the federal government to have an authority, a power, it has to be in the Constitution, it has to be listed. So let's start there. So when it comes to abortion, women's reproductive rights, as some might want to call it, is that listed anywhere in the Constitution as an authority for the federal government? And the answer is no. There is no authority anywhere in the Constitution. What is the ability to terminate a pregnancy a right? Well, let's examine what rights are. Rights are these things that you have. It gives you your liberty, your free choice. And they are, according to the Declaration of Independence, endowed to you by the Creator. So if your rights are endowed to you by your Creator, they're unalienable, they can't be taken away, then we have to ask, would the Creator who endowed you with these rights then consider abortion a right? Because if he's the one that's giving rights, then we have to look at what the Creator then would consider a right. So from a religious standpoint, obviously, God would not consider killing a baby in the womb a right. So it would not be a right from a religious standpoint. Well, what about a legal standpoint? Well, when it comes to a legal standpoint, your rights are enumerated. Some of them are enumerated in the Constitution, some of them are not. Ninth Amendment indicates that whatever rights are not enumerated in the Constitution are also rights and cannot be disparaged by the federal government or by government in general. And therefore, we have to figure out then, well, if it's not listed as a right, that doesn't necessarily mean it isn't a right. We have to determine if it's a right from a legal standpoint. Well, from a legal standpoint, we have the Declaration of Independence, life, liberty, and the pursuit of happiness. So life is an automatic right. There is no pursuit. There is no question. It is a right. Liberty also fits under that. So we got two challenges now here. The baby, if the baby is a person from a legal standpoint, has a right to life. However, the woman has liberty, and that would be the right of choice. So now we've got what we think might be a conflict. So then we go on to the pursuit of happiness. You don't have a right to be happy, but you have a right to pursue it. So in her pursuit of her happiness to achieve this right of liberty, question is, can that pursuit interfere with the rights of another? As I like to tell my classes, I have a right to swing my arms, but I don't have a right to swing my arms so that my fist connects with your nose, because you have a right not to be punched in the nose. So therefore, my right stops where the next person's right begins. So the question is, does a woman's right to terminate a pregnancy stop where the child's right to life begins? But we're told the child is not a person. It is an unviable fetus. That is the language used by the left and those who support abortion in order to make sure that it's legal and one right's not interfering with the other. If the baby in the womb is not a person, they have no right to life yet. Life, liberty, and property is listed in the 14th Amendment as being a right of persons. No person shall be deprived of life, liberty, or property without due process. So if the baby is not a person, then abortion would be totally legal from their point of view. So now the question is, okay, if that's the case, and this goes back to Harry Blackmun, right? The justice in the Roe v. Wade, he says, hey, once personhood is determined, this ruling becomes null and void. So is the baby a person? Now, science has helped out with that answer. And matter of fact, let me read something about science real quick. Science demonstrates that human life begins at conception, and knowledge of prenatal development affirms the humanity of unborn children. Heartbeats can be detected by roughly 6 weeks. I've heard as early as 21 days, as late as 8 weeks, depending. A baby can move in the womb around 8 weeks. The following week, all basic physiological features are present. At 10 weeks, a baby begins to form hair and fingernails. A baby may hiccup. At 11 weeks, at 12 weeks, a baby can sense stimulation from outside the womb and has a capacity to feel pain. Then from this particular article at the Heritage Foundation, it goes on to say, from the moment of conception, every person possesses inherent dignity and worth. Our humanity doesn't depend on our age or stage of development or our abilities. We also, again, now we can talk about also science. Follow the science. And in science with DNA, we know that everything about your humanity is in your DNA. The DNA does not form later on in the development. The DNA is present immediately at conception. So we have a lot of arguments indicating that an unborn child is a person. And if they're fully formed and look like a person, they have their hair and fingernails, there's a heartbeat. Now, is not a heartbeat a characteristic that's only to a living animal? So the argument here is prior to the heartbeat, fine. We'll catch that argument some other day. But after the heartbeat, no one can deny that that is a characteristic of a living animal. And in this case, a living human being. So the heartbeat is the primary indication of humanity in this bill, making that baby a person. So now we flash forward from when the law was signed to the challenges. And after, let's see, what was this, about 2 weeks ago, 3 weeks ago, The U.S. Supreme Court denied a request for emergency injunctive relief requested by Texas abortion providers. As a result, most abortion activity in Texas has come to a halt. Litigation will undoubtedly continue in the days and weeks to come, and it has. And the core principle, and this is what I've discussed already here, the law must protect innocent human lives, including those who are not yet born. In other words, human lives meaning persons. Is the baby a person? The Texas law prohibits most abortions after a fetal heartbeat can be detected via ultrasound, which is roughly at 6 weeks gestation. It also provides individuals from assisting a person in obtaining an illegal abortion. Now, in the past, these bills, these laws would require the officials to enforce the law. And instead, state officials are not given the authority to enforce the law. It is up to what's out there. And the state officials are granted a sovereign immunity against, or the law grants a sovereign immunity against anyone seeking to bring suit on the grounds that the bill is contrary to constitutional law. Private citizens, however, may bring a civil enforcement action against someone who performs an abortion in violation of the law. So in other words, the law is not being enforced by the government, it's being enforced by the people. In other words, you cannot have an abortion beyond that point of 8 weeks. However, if someone does, there's no cop that shows up and slaps on handcuffs or anything like that, but an individual then may bring suit against the person who then sought to get the abortion and the person who performed the abortion. So that's how this one, this one takes a little bit of a novel approach, and that's the reason why the courts are not sure what to do with it, because it's not really any different from the Georgia law in the sense of the heartbeat. Where it's different is the government, state government's not saying, oh no, we're enforcing it. No, they're saying no, it's a law on the books, but we're not enforcing it. Enforcement's going to be based on litigation brought against those who violate the law, which is a novel approach for sure. And it's funny because as a pro-life individual, I can't believe that this is even a question. I can't believe that this is even a consideration, something we have to talk about. Because be honest with you, to me, as it says, the Declaration of Independence, it's self-evident. Rule of law, self-evident. It's self-evident that that's a baby. We shouldn't even be having this conversation. Abortion shouldn't even be on the table. And sometimes I even ask the question, my gosh, when it comes to abortion, to whom are they sacrificing that innocent blood to? Because it sounds a lot like Bell to me. But nonetheless, this is what we're up against. So abortion is the law of the land. Now let's talk about that real quick. Because while I've talked about how we're going to challenge Roe v. Wade, now we must ask ourselves, is Roe v. Wade legal in the first place? Okay, so now remember, I talked about the enumeration doctrine earlier. Enumeration doctrine means that in order for the federal government to have an authority, it must be expressly enumerated in the Constitution. So first question is the word abortion, baby, procedure, medical, health, any of those things, reproductive, are any of those things listed in the Constitution as an authority to the federal government? And the answer is no. Therefore, there is no authority in the Constitution whatsoever for the federal government to be involved in that issue, period. So first of all, that makes Roe v. Wade an unconstitutional action, because the court shouldn't take the case in anyway, because it's a state issue then, and it was a state law that they overturned. In the 10th Amendment, it says this: the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. So if the federal government doesn't have the authority and it's not prohibited to the states, which it's not, in the Constitution, then it's a state issue. States can make their decisions on what they want to do on that issue, and the federal government is not supposed to interfere. But the federal government did. Federal court took that case. Supreme Court took that case. And when the Supreme Court took that case, they should have said, this is not a federal authority. You can't take that case. The ruling at the highest state court will be the case of record that stands. Well, if that's the case, the Texas Supreme Court had upheld the Texas law. This is talking about Roe v. Wade way back in 1973. That's always Texas. And none of this would be going on. So number one, federal government has no authority to even be dealing with this issue, and they did with Roe v. Wade. Number two, Article 1, Section 1 of the Constitution says that all legislative powers herein granted shall be vested in the Congress. All legislative powers. Legislative powers are the power to create law, modify law, and repeal law, or strike down law. Only Congress has that authority. All legislative powers herein granted shall be vested in a Congress. And vested means that not only are they given that power, they can't give it away. No one else can have that power. But here we got the courts striking down a law. Number one, that's a legislative action. Only the legislature who passed that law can strike down that law. In this case, the Texas state legislature. But we have a federal court striking down a piece of legislation, acting legislatively, legislating from the bench, as some might say. And that's totally unconstitutional. So 2 unconstitutional strikes against federal government when it comes to Roe v. Wade. So we have, it's a state issue, no business, acting legislatively, can't do that. Then, of course, we get down to life, liberty, and property, and due process. If the baby is a person, the life, liberty, or property cannot be taken from them without due process. Child is unable to be given due process due to the condition of their development. Therefore, their life cannot be taken from them because due process is not possible. Due process being the legal actions. There's elements of due process. You know, you have a right to know why you have been detained, arrested, whatnot, indicted for. You have a right to face the witnesses against you, to know the evidence against you, to obtain witnesses in your favor, to have counsel to represent you. All of these things are elements of due process, speedy trial, public trial, trial by jury, all of that. It's all part of due process. So there's strike 3. So we have, from a legal standpoint, every reason for Roe v. Wade to be unconstitutional. Now, that means if it's up to the states, it's, well, Doug, some states will be pro-abortion, some will be anti-abortion. I would hope they'd all go against abortion, but yeah, you're right. Well, then a woman would just cross state lines. So be it. The states, though, have the authority to make the decisions for themselves, because this is not a firm union national government system. This is a federation of states who are voluntarily a part of this union and retain sovereignty and autonomy for domestic issues. The federal government was created for the purpose of external issues and disputes between the states and things of that nature. Or as in Federalist 45, James Madison says, the powers of the federal government are few and defined. The powers of the states are numerous. And I can't remember the other word, but means forever. It doesn't stop. So we have a situation here where the wrong agency is trying to apply the law. And while we go back to it being a right. It's not a right. The federal government has no authority. It's a state issue. And an unborn child is a person. All of those things go against the federal government. But nonetheless, the Biden administration has vowed that they're going to go after this law. They're going to make sure it doesn't happen. And my question is, since when, Mr. Biden, are you a dictator and can dictate to states and control states? I know you've already said you're going to go after any governors, go against your mandate too, and there's 11 of them that said they will when it comes to the jab. The federal government doesn't have that kind of authority. The states can make their own decisions, just like I can make my own decisions. See, the states and people have something called liberty, and liberty is free will, choice, the ability to say no, the freedom to say no to your tyrannical ways. Now, that said, we understand, because we have a consent of the governed, we want to have an orderly society, that some laws are necessary. So therefore, there are some laws in place that we all must follow, and we all agree to it. So there are some things I can't make a choice on. I can't make a choice to rob a store because it violates the rights of the store owner. I cannot make a choice to jump into a vehicle and drive it drunk because it violates the rights of the people trying to drive safely on the roadway. So the necessary laws in place typically are to restrain ourselves from violating each other's rights. Because remember, my right to swing my arm stops at the tip of your nose. So those necessary laws are in place. But a law becomes unnecessary when it allows someone to punch someone in the nose as they swing their arms. When it forces someone to lose their right. So if someone is compelled to bake a cake, that's against their religious rights, or the life of a person is lost because they are punched by the mother who wants to remove them, to slaughter them in the womb. So there you go. That's the whole thing about this Texas law. I know this one went a little long. It's been a while, but it was necessary. Hope you learned something from it. Hope you appreciate what I have to offer. Subscribe to this page if you haven't yet. Visit the websites. I post on Political Pistachio. That's the blog. DouglasVGibbs.com is my main website. Still working on a few things on that site to make it easier to navigate, but for the most part, it's there. Go into the link bar. There's drop menus. You can find everything you want to find, Constitution classes, whatever. And of course, I have no problem with you donating. I have 2 radio programs that I fund myself. I fund everything I do, and it's mostly paid for by the money that's made from the classes and donations from folks like you. So if you want to help out, feel free. Until next time, united we stand, combined we kick butt. God bless America, my friends. God bless you. Thanks for watching, and we'll see you next time.